Good morning, Your Honors. I'm Brian Esser of the Nashville Bar. If I could take a minute to introduce my co-counsel associate. This is our first time to be in front of the Supreme Court, even in the building. This is Madison Waits. She's a 2017 graduate of Gardner-Webb in Bowling Springs, North Carolina, and a 2021 graduate of Belmont School of Law.
Okay, did you say Waits, Ms. Waits?
Wait, yes, Your Honor.
Okay, welcome to the court. Glad to have you. Thank you.
I'll be in trouble walking back down the hill because I did not tell her I was going to do that. but thank you all. As you know, I represent HTI Memorial Hospital Corporation, which is doing business as TriStar Skyline Medical Center. For brevity's sake, I'm going to reference it as Skyline Medical Center, Skyline, or the hospital. That's a mouthful as we get into these types of arguments. And I know Your Honors, this is the first time I've ever been in an appellate decision on the heels of another case that factually and procedurally were indistinguishable. So I don't know really
just start answering all of the questions that are posed.
Well, I'll start with Justice Bivens. I agree with Justice Bivens. This is a straightforward, I believe, application of the Absher case in combination with the Tennessee Healthcare Liability Act.
Mr. Esser, let me ask you,
Yes,
there's
sir.
a little bit of difference between this case and the Gardner case. This one was decided on a motion to dismiss, right?
Yes, Your Honor.
And also you have actual agents here versus apparent agents in the other case.
I think, yes,
Right.
Your Honor.
Does that make any difference in our analysis?
Not in the analysis as it relies to the application of Absher, because Absher doesn't make that distinction between actual agent, apparent agent, or some other type of agency relationship. I think the fairness argument, if it's truly my employee, not to use the fairness argument, I don't have that argument because I can interview my employees. However, when you look at the complaint that was filed, it's not exactly 100% clear. Is it just employees or is it other agents? And we're having this battle weekly, monthly in courts now, trying to figure out who are you suing me for? Is it my employee or is it an agent or is it a combination of those things? But to answer Justice Bivens' comment, I do believe applying Absher to the Tennessee Healthcare Liability Act case results in the dismissal of these cases when a plaintiff chooses to sue only a hospital in this setting and not give the pre-suit notice or include the underlying agents.
So you think that the agents have to be given notice and trigger hiring attorneys and everything that entails?
Under the application of Absher, yes, sir, because the case is, I believe, unequivocally clear that if the claim against the agent has been procedurally barred at the time the claim is made of agency against the principal, applying that rule of law,
So why should we extend Absher to this very different factual scenario?
I heard
That's the million-dollar question, I think.
I heard that question earlier, and I was thinking of a scenario.
You were thinking of the right answer.
I was hoping to have the right answer, yes, ma'am. But in Absher, the claim against the principal was timely made. So the decision and the analysis by this court in deciding whether...
In Absher, the limitation was the same for
I
both.
agree, Your Honor.
So that's a different factual scenario.
I agree, but the claim was made timely against the principal for the actions of the two physicians, which I believe you all described as gratuitously dismissed later in the lawsuit. In this setting, under the Tennessee Healthcare Liability Act, you could have, again, identical facts, identical procedural history, two lawsuits filed. The first lawsuit not include a claim of agency that continues for a couple of years. The second lawsuit include the claim of agency, and the argument that's being made is they didn't have to do anything other than just sue the hospital and give me notice. But in the first lawsuit, if they later tried to amend to relate back when they did not include the claim of agency in the initial lawsuit, Absher would be, again, spot on.
Let me ask you this. If, in this case, the plaintiff had sued the agents right out of the gate and then voluntarily dismissed those claims. And then later, within the statute of limitations, plus the 120-day extension, had sued the principal under a vicarious liability theory, would Absher bar that claim?
No, ma'am.
So why is the situation that we're in not any different from that, where a plaintiff had no intention of suing the agents at all at any point during the litigation? Isn't that sort of the equivalent of, how can that plaintiff be in a worse position than a plaintiff that voluntarily dismisses claims against the agent at an earlier point in the litigation?
Well, that's just, I hate to say it, but that's the way Absher held, and applying Absher as it presently stands, when you make a claim of agency against the principal, if the claim against the agent has been procedurally barred, it's an improper claim of agency. If they sue the agents and the principals all together when they file the lawsuit and it include the claim of agency, that would satisfy the fourth exception to Absher.
So going forward, a plaintiff who doesn't want to sue the agents but wants to get the benefit of the 120-day extension just needs to sue the agents and then voluntarily dismiss the claims?
Well, that would be a way to salvage the claim of agency. Yes, ma'am.
So to follow up on Justice Campbell's question, though, the essence of her question is, how does that make sense? How is that fair? There were policy reasons undergirding the holding in Absher. How do those reasons apply in this very different factual scenario?
At the risk of talking about fairness, in the scenario that Justice Campbell just described, these other agents, other providers would have been provided pre-suit notice and some participation potentially in this 120-day grace period where some effort is intended to see if the case can be resolved. They all would be participating. They would all be with counsel and potentially reviewing their care, reviewing the case.
But that's not what Absher is about. That's not
not.
what Absher is concerned with, is like providing all of the potentially relevant parties in litigation an opportunity to discuss settlement. That's not at all what motivates the limitations in Absher, is it?
Not in Absher, but addressing how it would work if you did include the principles in fairness. I think that's what I was trying to address without.
Well, we take the statute as it is written, but Absher was intended to address an essentially unfair situation. And I don't see how applying the holding of Absher under these facts addresses the problem that Absher was getting at.
Well, Absher allowed the claim to continue, the agency claim to continue, because it had been timely made. So it identified the exception, but applied it to rule that the claim of agency for the then dismissed defendants could proceed.
Doesn't your argument, though, that the plaintiff, to Justice Bivens' point, the real issue is whether the plaintiff has to give pre-suit notice to agents, even if they don't intend to sue them. And the part of the point of the Health Care Liability Act is to give the parties an opportunity to settle. If the plaintiff gives pre-suit notice to every employee who they can detect from the medical records touched this, the plaintiff, how does that advance the legislature's intent that the party, how are they going to settle it with all those people? Whereas if the plaintiff makes it clear, I'm just suing the hospital here, then there's a real opportunity to engage in discussion with the hospital and possibly settle.
Well, I don't want to get too far in the weeds with this, but when you get these independent medical providers, as you saw in the Gardner case, you run separate insurance carriers, separate parties, separate intentions, where they're just looking to the hospital to pay everything when it's not the hospital's responsibility financially. So adding and including all of these individual providers on the front end through the notice provisions would allow the substantive involved parties to substantively and hopefully, if that's the goal, participate in getting the case resolved if there is an effort to resolve it, instead of just looking to the hospital as the principal for all of these independent apparent agents or ostensible agents.
So if the plaintiff gives pre-suit notice to 50 potential defendants as agents, you're saying that actually makes it easier to settle?
I didn't say make it easier, but it would allow an opportunity for those non-employed participants to participate.
What about the employee participants? Say, under your theory, I think the plaintiffs would have to give notice to every hospital employee who touched this plaintiff, and that would be CNAs, nurses, anesthesiologists, or assuming they're, well, those would not be actual employees, but just everybody who touched the plaintiff to be safe. I don't see how that benefits the hospital.
Well, it does not, but I believe what we have seen in these healthcare liability actions, you don't sue the hospital based on everyone from the registrar to the nurse who dismisses or walks the patient out to the car at the end of the admission. With the requirement for the certificate of good faith, that's kind of rolled into this. They focus the care on, or the claim on, the care at issue in the case, and sometimes we can identify that based on just the notice letter. Many times we don't. We cannot. And so we're, again, not in fairness, but disadvantaged in some cases trying to figure out what the claim is going to be about. So including these providers who truly are, their care truly is at issue, at least focuses the claim on those points and those periods of care, especially in a hospital setting. When hospitalization could be 1 day, that's easy. 6 weeks, when there's no slip and fall getting out of the bed, no surgical misadventures, it's sometimes called, or whatever it is, it really hamstrings the ability to do, as Your Honor suggested, trying to figure out what the claim is about and whether we should resolve it or not.
Plaintiff may not even know that at the outset either, right? I mean, sometimes the plaintiff has to dig into the records and do discovery to figure out who actually had the misadventure.
I suspect that is true sometimes, Justice Lee, but a lot of times we deal with sophisticated lawyers in these kinds of cases. Not that other lawyers are not sophisticated, but they can hone in on what the claim is because they've had the opportunity to talk to the family and figure out why are you coming to see me today, in other words? What's the issue in the case? Whereas when I get a notice letter sent to me from my hospital, I'm thinking, okay, well, send me the records, let me try to figure it out. And I hope I get the records before the 120 days lapses. I don't want to just waste time up here either because you all have had 2 opportunities to hit the piñata today. So I'll gladly answer any questions you have about our position, but I will take issue one thing that was said earlier. And I believe filing the lawsuit within the statute of limitations doesn't salvage it because you still have to give the pre-suit notice, and that's the issue we saw in the Taylor case. They did not give pre-suit notice to I think it was a social worker in that case. So you have to give the pre-suit notice. Filing it within 1 year doesn't save it. You still have to give the pre-suit notice to take advantage of, to comply with 292611.
If you just sue the principal and you file within 1 year, you don't have to give notice to the agents.
No, ma'am,
right?
I think you still have to.
You think you still have to?
Yes, ma'am.
Well, why is that?
Going back to Absher, because the claims against the agents would be procedurally barred when you file it because you haven't given the pre-suit notice.
Because you haven't given pre-suit, huh?
I hate to muddy it even more, but
No.
I think you have to comply with 121 fully to salvage and not have the claim procedurally barred when you file it.
So the plaintiff
Even
is
if
really,
they file within 1 year.
Even if they give pre-suit notice, so if we're talking about the options identified as ways to reconcile Absher and HCLA. So even if you would say under option 1, if they provide pre-suit notice to the principal 60 days before the statute of limitations expires and then sue within statute of limitations, that would still be barred if they did not, that would still be barred under ABSHR if they did not provide pre-suit notice to the agent?
I would apply 121 that way. Maybe I'm misapplying it, but I've always worked under the
Can
presumption.
you explain that a little bit more? Why that would?
You lost me on that
I
one.
didn't understand that from the brief. So
See, you were all ready to sit down.
Maybe I should go sit down now.
No, I mean, I think you can read the statute that way.
Yes, to satisfy the
think,
requirement, you can
yeah,
file
I
the
can see where
lawsuit
you-
within 6 months of the event if you
Right.
wish. But you still have to give the pre-suit notice, and you have to wait 60 days after giving the pre-suit notice.
I understand that. Where I'm a little baffled is to say that even if the plaintiff did that and filed within the 1 year statute of limitations without the extension, that would still be barred because the notice wasn't provided
I
to the agents.
must have misspoken. If you give the notice, then the case is not
if you give the
precluded
notice to the principal.
to both.
Okay, but why would you
Why-
have?
yeah.
I'm that's where you're losing.
Yeah, that's
me.
where you're losing us. Is, well, why would you have to give it to the agents at that point?
Because the time you file the lawsuit against the principal, it is procedurally barred against the agent because you haven't satisfied,
Yeah.
You didn't give the notice.
you didn't
But
give
you
the
never
notice.
wanted to give it. You never intended
It's
to
an
sue.
independent requirement. You
Yes.
have to file within whatever the appropriate statute of limitations is and give pre-suit notice.
I'm glad we
in
don't have
order
to resolve that
maintain.
issue.
So the bottom line is, a plaintiff who just wants to go right straight to the target defendant at the hospital is at a really severe disadvantage for a lot of reasons. It's to every plaintiff's advantage to sue multiple parties and give multiple notices to get the benefit of the 120-day extension and to not run afoul of ABSHR, under your theory.
Well,
And you don't make the law, that's just, I mean, that's the actual effect, right?
Yes, Your Honor, I believe applying the law as it presently stands, and you all may correct that for us and give us some guidance, but applying ABSHR to the Tennessee Healthcare Liability Act, if you're taking advantage to just sue the principal, you better have given notice to the agents.
Which agents?
I'm sorry.
Which agents? I mean, any conceivable
It goes back to what,
individual entity that could have been sued?
no, ma'am, the participants who you're trying to hold me responsible for as the principal. The agents that you think did something
For which you are vicariously liable.
Yes, ma'am.
I understand your reasoning, but you would agree that that is an extension of ABSHR, correct?
Extension. I think it's an application of ABSHR. It would be my interpretation.
It's an extension of ABSHR to a different factual situation.
Yes, Your Honor,
correct?
because ABSHR, as you point out during the first argument, was before, the facts of that case occurred before the Healthcare Liability Act required the pre-suit notice.
Gotcha. Thank you.
I think I will sit down before I,
All right, thank you.
thank you all.
Thank you.
Beat the clock. Good morning, Your Honors. Rick Peloponus on behalf of the appellee in this court, the plaintiff in the underlying action in this case. I think one of the things I want to address at the very, very top is that we can give notice to everybody in the world, but to do so, we have to violate the plain language of the statute in this case. The plain language of the statute says you will give notice to those who will be named defendant. That's
Wait a
it.
minute, you're not violating the language of the Healthcare Liability Act by doing that. You're going beyond the
You're-
plain language perhaps, but you're not
You're-
like violating it, are you?
You're giving notice to people who will not be named a defendant in your case. That's in clear contradiction to the plain, simple language of the statute. This case is really focused on interpreting and upholding the legislature's intent and purpose of the notice and the extension provisions of the Healthcare Liability Act. And that's why we're here. We've briefed the statute, we've briefed the definitions, but what we're asking the court to do is to construe the extension statute to affect the legislative purpose of that statute, which is to give an extension for all healthcare liability claims against a provider, regardless of the theory of liability. It's right in the plain language of the statute. And that would include vicarious liability claims. That is just a theory of liability against a healthcare provider. And we're asking also that you don't impose new requirements that would shorten the statute of limitations as to a provider, as is directly prohibited, which is this giving notice to all these other people. And this is, I think, a clear, straightforward statutory construction issue where you apply those statutory construction guidelines, where you look for the intent of the statute from the plain words in the statute. You don't force construction to limit those words to something beyond their plain meaning. And if it contradicts with the common law or existing common law, statute controls, and it overrules that common law. And I mention those kind of at the top because that's what we're doing here. The first thing you've got to look at is the plain language in the act on what a plaintiff is required to do under the act. And by giving that notice, what that means, what notice you're giving to that defendant. And I will say, as we get into these arguments about, oh, you can give notice to all these other people, you can give notice, that just ignores the plain language of the statute. The plain language of the statute says you give notice to those who will be named a defendant. Defendant doesn't make any argument to this court that that language is ambiguous or unclear or vague or for some reason cannot be applied in this case. And the defendant is essentially asking the court to ignore the plain language of the statute and hold that Absher versus Methodist overrules the act instead of the other way around, that you've got to give notice to all of these other people who will not be named defendants to get the benefit of the extension against the one party that you will be naming as a defendant. And I would say that the repeated reliance on Absher, and at the trial court at least on the legislative history, and the disregard for the plain language of the statute is unhelpful to the court's statutory interpretation of the notice and extension provisions that are in the Healthcare Liability Act. Absher, there was no pre-suit notice given in that case because that statute didn't apply to this case. The definitions of what consisted of medical malpractice were different at the time that Absher was filed. So when you were filing a case, and that gets into your Estate versus French and the Ellithorpe case. Under the old law, someone would sue a nursing home, they would sue them for medical malpractice under the Medical Malpractice Act, and then for ordinary negligence for their CNAs. They give water, they feed people, they turn people, they take them to the bathroom. Those were not licensed professionals, those are just certified nursing assistants. Those were just ordinary negligence claims. So the court had that balance, and that's why they decided Estate versus French. But then when the Healthcare Liability Act was enacted, that changed that landscape. Healthcare liability claims became all of those things under the umbrella of a provider. So this court has already recognized in Ellithorpe that the definition of what healthcare services are is important, and it's broad. It's very, very broad. The conflict regarding who was to receive notice and the effect on all claims asserted against the party receiving notice, I believe was resolved appropriately by the appellate court in this case. The definitions in the plain language of the statute are important, and they're clear here. And defendant doesn't even argue that the statute is unclear or is ambiguous in some way. They just want to say, don't look at the statute, look at Absher over here, and not recognize the clear conflicts between holding that Absher applies to the Healthcare Liability Act without regard to what the Healthcare Liability Act says. So as we look at the definitions of what is in the Healthcare Liability Act, it defines an action as 2926-101A1 defines an action as any civil action regarding healthcare services, regardless of the theory of liability. That's the broadness of what a Healthcare Liability Act claim is against a healthcare provider. There's no dispute that the defendant is a healthcare provider, they're a hospital. They fall under that definition. That's not at issue. 2926-101B defines what those healthcare services are. And those healthcare services are all the services under the scope of a provider, including actions by their agents, employees, and representatives. It's clear that the legislature intended that when you give notice to a healthcare provider, you are giving them notice that you are suing them or potentially suing them over their failure to give or their negligent provision of healthcare services. And what those healthcare services are include all these actions by their employees, their agents, and their representatives. It's right in the statute. And well, I'll argue that in a second. The Healthcare Liability Act was created to provide a framework for medical malpractice cases. And it was to do that to promote resolution of those cases without litigation and to do so without shortening the statute of limitations. Those are stated purposes right in the statute. And in order to promote resolution, that's why the statute required the notice provision. The whole purpose of the notice provision is to give the defendants notice to say, hey, there may be something here. Let's look into it. Let's see if we can discuss this. Defendants have acted like they operate in a vacuum and they don't know who's going to sue them. They get notice from a plaintiff's attorney with a HIPAA that allows them to get all the medical records that that person has. Since the legislature did not want to shorten the statute of limitations, they enacted the extension provision. And that extension provision, so if someone came to us late and we filed a notice at 11 months, 29 days, you still would be able to get the benefit of bringing that action. They did that extension provision, which is wholly remedial in nature. It is just to remedy that problem of shortening that statute of limitations, so that since you're faced with a remedial statute, it's got to be liberally construed in order to affect the legislature's purpose. And so we need to look at what that purpose is. The statute, the extension statute doesn't say anything specifically about vicarious claims. It doesn't say that those are included, those aren't included. But the definition of healthcare services already includes all of those claims, because the definition of healthcare services includes actions by agents, employees, and representatives. So they're on notice that those are claims that are within their healthcare services umbrella that the healthcare provider is providing directly. Even though they're providing them through agents, employees, and representatives, in a vicarious manner, they're providing those healthcare services. They're liable for those healthcare services under the Healthcare Liability Act, because that's how the act is written. So, in order to determine what the intent of the legislature is, you got to look at the plain language of the statute, not forced construction, and if there's an unresolved conflict, then you go with the statute. So, since it doesn't say anything about that extension provision, our position is that you have to extend the statute for vicarious claims to make sense with the plain language of the statute. And that's the only way to make sense with the plain language of the statute, because you can only do a couple of different things. You can do as the appellant suggests here, and require that plaintiff give notice to a slew of individuals who will not be named defendants to get the benefit of the extension against the one party that will be a named defendant. And that is in direct conflict with the plain, clear language 2926.121A1, which says you will give notice to each provider who will be a named defendant. So you have to ignore that plain, direct statement in order to follow what they're saying you have to do, in this case, to Frankenstein Absher over the Healthcare Liability Act, because it wasn't a Healthcare Liability Act claim. Or you have to find that that language is somehow vague or unclear. And defendants don't even argue, or appellants don't even argue, that that language is unclear. They just ignore that and say, well, you can give notice to all these other people who will not be named defendants. You can also say that vicarious claims weren't contemplated by the legislature when they enacted the extension provision, that they just didn't, that the extension doesn't encompass those claims. It only encompasses some claims against a defendant and not others, which would be those claims of, excuse me, actions by the agents, employees, and representatives.
Counsel, can I
Yeah.
let me ask a question about I guess your thoughts on the best way to decide this case? I mean, if we were to hold that the Absher fourth limitation simply doesn't apply in this situation, would you agree that we wouldn't have to sort of get into the question about whether there's a conflict between the HCLA and the common law and how to whether there's a way to reconcile those provisions?
I think you could do it that way, but I think I think you can absolutely do it that way by reading the plain language of the statute, and that was the point that I was going to raise, is that you have the option that since you give notice to a provider, a healthcare provider, that you're going to bring an action for healthcare services, and those healthcare services include all of these actions by these agents, employees, and representatives. When you give them notice, you get the benefit of that extension, and that extension applies to all claims asserted against that, like it says in the statute, because an action is just all the claims, regardless of the theory of liability, that go against that particular defendant. So I think you can short circuit, I guess, in effect, Absher, because it doesn't really apply to the Healthcare Liability Act, because it is in conflict with the Healthcare Liability Act. But
I guess just looking at kind of the policy reasons that underlie the limitations announced in Absher, I mean, would you agree that the fourth limitation doesn't squarely apply to the facts of this case?
I agree. Yeah, I don't think the fourth limitation, because they're talking about the statute of repose and other issues as complete bars to bringing an action against somebody, and that doesn't apply here.
And can you talk a little bit more about the distinction between a statute of repose and statute of limitations, and what significance that has in the context of this case, in your view?
Well, sure. A statute of limitations, and that's I guess the other important issue, as we talked about, or as Justice Lee had mentioned, when a plaintiff gets a medical record, and you get some scribbled signatures, and you get some initials, and you get all these different people. You have no idea who they are. The action for the plaintiff is only, the statute of limitations runs after the plaintiff knew or reasonably should have known of the malpractice of someone who committed malpractice. At the point that we're suing just the hospital generally, there are a bunch of agents in there. There are a bunch of people in there, and you're also including omissions. So that's not even going to be in the medical record. That's all through the discovery process. The statute of limitations doesn't really run against those people you can't identify as committing some sort of malpractice. The statute of repose, on the other hand, being a 3-year absolute cutoff, whether you know or you don't know that there's been some malpractice, that's just a complete bar to your ability to bring an action. The statute of limitations is, in healthcare sense, is a discovery rule. So
you would say, is it your position that that's not the sort of procedural bar that Absher was contemplating?
Absolutely. Absolutely. And I think you're still in, yeah, it's not. The absolute bar that Absher actually talks about is the statute of repose and not the statute of limitations.
What's the practical advantage to the plaintiff of putting your eggs all in one basket and only suing the principal for vicarious liability and not the agents?
I don't know that it's an eggs and all in one basket proposition. I think obviously the practical advantage is that you have the party who is ultimately going to be responsible, that in a realistic sense is ultimately going to be the one bargaining and responsible for that action. But from a more practical sense, you may not know who all of these different agents are. And I guess the idea that you could serve notice on a John Doe and that would solve all this problems is not something contemplated by this statute and is really against the plain language of this statute. The statute says you will only give notice to those who will be named a defendant. So if the notice provision doesn't apply to vicarious claims, then the result is you're shortening that statute of limitations for vicarious liability claims.
Well, you're not shortening it, are you? You're actually just not being able to take advantage of the extension.
Well, yeah, but I think that's the whole purpose of the extension. And I think I don't agree with the defendant's position here, or the appellant's position here, that if you file within 1 year that you somehow are going to get bounced out because your claim is not still viable against that agent. Your claim would still be viable against that agent because you can still give notice within that 1 year. So the idea that that claim has extinguished because you haven't given them notice, I think is a fallacy. That is not an operation of law restriction to filing that claim. So we're asking the court to read common sense into the extension that the purpose of the act is to give notice only to the defendant that you intend to sue, knowing health care liability claims versus that defendant include vicarious liability claims already, because it's in the statutes. It's written as to what health care services you are bringing an action against them for. And to maintain the same 1 year statute of limitations, the extension granted extends the statute of limitation for health care liability claims, including agency claims against the provider, as the statute plainly states. And we think that's the only interpretation that gives this statute its plain language meaning. It's the only meaning, the only way you can interpret the plain language of this statute and apply it here. I don't think that means that once you give notice to the principal, I think the defendant or the appellant had suggested in their brief that then you could sue all these different agents. That's not what we're asking for here. That's not what we think that means. I think you're still bound by who you give notice to. I also wanted to address this idea that you can just willy-nilly give notice to a whole slew of different people that you don't intend to be defendants in your action, because that is not without consequence. I think, as Justice Kirby had pointed out, say you give notice to 50 people, which theoretically in a hospital case you could. If it's a long-term hospital stay, you have a bunch of nurses, it's a pressure sore, you have a bunch of nurses that have seen that person on a bunch of different shifts, you give notice to 50 people. When you give them notice, those folks believe that they are subject to a potential lawsuit. They must hire attorneys, must notify their insurance providers, must possibly notify the state.
Well, but the employees would simply notify their employer, not go out and hire a lawyer for themselves.
What if the employer says, this is not our
Well,
problem?
if that's in that situation, yeah, but in a run-of-the-mill situation, most of the time, employees are not going to go out and hire separate attorneys. They're going to turn it over to their employer, and the employer is saying, we've got this.
Even granted that, the practical effect of what is happening with a notice to somebody is that the plaintiff is giving a completely unfettered HIPAA release to all of these different people. All of these different people who are not contemplated to be named in a lawsuit, will have unfettered access to that person's medical records, whether they turn it over to their employer or not. They'll have the ability to go to any healthcare provider that person has seen and gotten all of their private healthcare records. That's the effect of giving notice to somebody, and that's clearly against the goals of HIPAA. That's clearly against the privacy goals of this state. And that's against the policy of this state. And it's unnecessarily just by simply construing the statute to apply the clear legislative purpose, which is only give notice to those people who will be named defendants, grant an extension for all claims that involve health care services against that person, which include, or that provider, which include claims of actions by their agents, employees, and representatives, and give an extension for those claims regardless of the theory of liability under which you're going to pursue that health care provider. I think it's important that the court recognize that the extension is not claim specific, it's provider specific. Your claims against that provider are what are extended, not the specific claims, because your claims are any claim, regardless of the theory of liability that you're bringing it against that provider. We just ask that the court affirm the appellate court and construe the statute for the purposes for which that statute, that notice and extension statute, was enacted. Any questions? I know you've had plenty of time to.
Sit down quick.
Thank you.
We used our questions on a lot of other people. You kind of got the benefit of going after a lot of people.
Mr. Esri?
Your Honor, Mr. Esri didn't ask for rebuttal time, so how much rebuttal time would you like me to give him?
I'll just take a few minutes. I think I
How
have,
about 5? I think you have 12 left, but we'll give you 5.
oh, hopefully less than that, Your Honor.
All right.
Just a couple of quick points, and I apologize for not expressly reserving. I got off on Ms. Wade and forgot to do that, so I apologize. A couple of quick points. One, as it relates to the healthcare liability action, talking about the defendant that you intend to sue. Unfortunately, my name is yoked to the case that allows a direct claim against hospitals, the Barks versus River Park Hospital case, where I think Justice Lee actually wrote the opinion, said that there is now recognized a direct claim against healthcare facilities, not based on vicarious liability or anything else, just a direct claim because I was able to defend the vicarious liability claims in the case and lost on the direct agency claim. So yes, you can sue a hospital like Skyline Medical Center directly for the negligence of the hospital without including a vicarious liability claim. However, under Absher, if you're going to include a vicarious liability claim against the hospital, you have to comply with Absher and make sure that that vicarious liability claim is not extinguished before you make it. That's point one. Point two, if I can get my glasses, sorry. Point two is the definition that has been cited several times today, or the verbiage from 2926 101 about, quote, other agents, employees, and representatives of the provider. That's at the end of a litany of all the other types of healthcare providers identified under subsection B when it defines healthcare services to persons includes care by healthcare providers, which includes physicians, nurses, LPNs, et cetera, et cetera, et cetera. And then it goes on to say, and other agents, employees, and representatives of the hospital. The General Assembly was simply was trying to make this as broad as possible to address then the argument that these claims against providers were not falling under the Healthcare Liability Act. It was not intending, the General Assembly was not intending to somehow use that language to say, to circumvent or to overturn Absher, to say you can sue agents, employees, or representatives under the Healthcare Liability Act without fulfilling the requirements of Absher.
Let's explore that a little bit.
Sure.
Because the pre-suit notice provision says that you give notice to defendants you intend to sue.
Yes, ma'am.
And that's regardless of the theory of liability. So how does, if the plaintiff doesn't intend to sue the agents, is it implicitly contradictory, at the very least, of Absher to say, no, if your theory of liability is vicarious liability, there's an additional requirement out there not stated in the statute, or that you have to, in fact, give pre-suit notice to defendants you don't intend to sue.
I believe that's the application of Absher, Your Honor.
But Absher, I mean, I guess you're focusing on the limitations of Absher, but the core rule, the kind of heart of the common law rule at issue in Absher is that a plaintiff can choose who to sue. Isn't that right?
Yes, ma'am. That's been the longstanding rule in Tennessee. You can sue the principal, the agent, or both. However, there's some exceptions outlined in Absher that if you opt to sue, you know this, Your Honor, if you opt to sue the principal for the actions of the agent, the claims against the agent cannot be procedurally barred. So that's the application of Absher to this factual scenario, which resulted in the dismissal.
And what do you think is the rationale underlying that limitation? How would you articulate that?
It goes back to what you said, the frontal assault versus the, I forget the exact term.
Encircling movement.
Encircling movement, yes, Your Honor. Because we find ourselves in these settings trying to defend claims that I can't even speak to the providers to do. For example, the physicians, I think that was mentioned earlier, the anesthesiologist. I cannot defend the anesthesiologist. I cannot present them for depositions because they're not my employees. So that's the encirclement that we see in these kinds of settings when you're not including them in the case. Instead of the frontal assault against the anesthesiologist, my light's on, so I guess I need to stop talking. Thank you all.
Thank you.
Thank you.
Thank you all. We'll take about 10-minute recess.
All rise.
Absolutely.
That was a huge faux pas. That was huge.
She's an attorney. She does a fabulous job.
That's fine. Glad to have you, Ms. Martin. Thank you.